Welcome to the COVID-19 and the Law TIE Talk series presented by the TIE Center for Law Science and Innovation at the SMU Dedman School of Law. My name is David Taylor, and along with Keith Robinson, I serve as a co-director of the TIE Center. This TIE Talk explores legal issues surrounding the COVID-19 pandemic. Today's installation of our TIE Talk series is entitled COVID-19 and the Constitution. Today's speaker will be Dale Carpenter. He's the Judge William Hawley Atwell Chair of Constitutional Law, and he's a professor of law at the SMU Dedman School of Law. A Texas native, he received his BA degree in history, magna cum laude from Yale College, and his JD with honors from the University of Chicago Law School, where he was editor-in-chief of the University of Chicago Law Review. After serving as a law clerk for Fifth Circuit Judge Edith Jones, he practiced at the firms Vinson & Elkins in Houston and Howard Rice in San Francisco. Prior to joining SMU, he taught for 16 years at the University of Minnesota, where he served as a distinguished university teaching professor and the Earl R. Larson Professor of Civil Rights and Civil Liberties Law. Before Professor Carpenter begins his presentation, let me cover two administrative points. First, I invite you to submit questions for Professor Carpenter using the Q&A feature on the screen. Following his presentation, I'll moderate a question and answer session. Second, for any practicing attorneys joining us who would like CLE credit, if you did not submit your bar card number during registration, please submit your bar card number by email to tiecenter@smu.edu. That's TSAI Center, CENTER, at smu.edu, and we'll register your CLE attendance. With that, I'll now turn you over to Professor Carpenter.
Hi, David. Thank you for that introduction, and also thank you to the TIE Center and to all of you for attending today. And I also want to especially to mention Natalie Greco, who has been so helpful in setting up this talk for today. I do want to talk about COVID-19 and the Constitution, although it might be more appropriate to speak of COVID-19 and the constitutions in the plural, because to some extent, what I'll be discussing today deals not only with the federal Constitution, although that will be my main focus, it also deals with the issue of the interaction of the law and state constitutions. COVID-19 is obviously a matter of ongoing and absorbing interest in the United States. We have no, and around the world. We have no cure at this time. We have no treatment, proven treatment that reduces mortality rates. We don't have an approved vaccine in this country, although we're hopeful of getting one. And because people may infect others and be asymptomatic at the same time, this disease presents very special perils to public health. Speaking of public health, as you know, more than 225,000 Americans are dead, as confirmed dead, just in the United States. We've had more than 18,000 deaths in Texas alone. That is the second most in the country, behind only New York. We are actually ahead of California in deaths, even though California has a third more people than Texas has. We have, at last count, I think somewhere north of 8.5 million, maybe 8.67 million confirmed infections in the country, although that number is actually much, much higher. Texas actually leads the country in confirmed COVID-19 infections. It's a serious thing. We have seen disruption to family and social life on a scale that none of us have ever witnessed in our lives. Obviously, all of us have felt the impact on education, certainly at SMU, but across the educational system in the United States. We have seen economic consequences that are far-ranging and deep, consequences of both the pandemic and the countermeasures that have been taken to try to combat it. Unemployment, business failures, hunger, lost health insurance for millions of people, huge expenditures, loss of GDP. The devastation just goes on and on and on in that realm. There is no area of life that has been untouched by the pandemic. And I think it's also fair to say that there is no area of public policy that has been untouched by the pandemic. It has generated a full range of governmental responses. Now, some of those responses are not terribly controversial, some of them are, and I hope to talk about just a few of them in broad terms today. I'm not going to offer any definitive answers to at least the most controversial questions. First of all, because that isn't very fun. Second, because I don't know that there are really good definitive constitutional answers to these countermeasures, at least the most controversial ones. And I think to some extent, the answers, to the extent we can get to them, are going to be provisional and contingent. They may in fact shift over time as our knowledge of the pandemic and our knowledge of the effectiveness of countermeasures gains ground. We hope at least it gains ground. So my goal in this talk this afternoon is actually much more modest. What I want to do, instead of offering definitive answers, is offer a framework for how to think or how to analyze some of the constitutional issues that are involved in these governmental responses that I'll talk about. A couple of things I'm not going to do. I'm not going to talk about voting rights. That was the subject of my colleague Grant Hayden's excellent talk of a few weeks ago. So I'm not going to mention that, even though I know obviously voting is very much on everybody's mind. But I advise you to take a look at the YouTube presentation that's available on that service. I'm also not going to talk about criminal law or criminal procedure and the criminal procedural rights in the Constitution. That will be the subject of my colleague Pam Metzger's talk in a couple of weeks on this same COVID and the Law series. So be expecting that, and I urge you to attend it. I'm also not going to pretend to be an expert in public health or in public health law or epidemiology. For that, I refer you to my colleagues like Tom Mayo and Nathan Cortez, who know a great deal more about that. I'm just a constitutional lawyer who pretends to know something about some of the issues involved in this pandemic and its response. Let me just lay out sort of the basic structure of American government when it comes to the subject of health powers and what kinds of powers the government can exercise in responding to the pandemic. And I've got in mind here a PowerPoint, and I hate PowerPoints because I don't think they're very effective and I don't know how to use them, but I'm going to try to use them today. So bear with me if you can, as I search for these buttons on my computer screen. Hopefully you will be seeing here step one, what I regard as the step one issue in analyzing questions of pandemic response for constitutional purposes. Now you could divide what I'm calling step one into a whole bunch of different steps. For ease of reference throughout this talk, I'm going to refer to it as the step one analysis. And this analysis basically asks the questions that you can see on the screen, hopefully. Where does the power to deal with COVID-19 come from? What's the constitutional source of that power, at least in the federal constitutions and also relatedly in the state constitutions? Relatedly, how is that power allocated between the state and the federal governments? And then depending on how the power is allocated, whether it's federal government or state government, how is that power allocated or separated among the various branches of the relevant level of government, whether it's the state or federal governments? Is the power, the kind of power that's being exercised, appropriate for the legislative branch, for the executive branch, or for the judicial branch? And then I think there's a last sort of step one question. However, it's appropriate for the actor in the government to be acting, whichever government is the appropriate actor. What is the scope of that power, and how do we determine what the scope of that power is? And these are important questions because they raise, I think, the real questions you understand from your Con Law 1 class. And these are questions of federalism. They are questions of separation of powers. They're fundamental questions in American constitutional design. And that leads me to a quote. You can never have a presentation on constitutional law without some quotation from James Madison and from the Federalists. So I'll just say what I think is the issue when it comes to step one. Madison said in Federalist number 47 that the accumulation of powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, may justly be pronounced the very definition of tyranny. In the view of the framers, at least, of our Constitution, and I think also of our state constitutions, the separation of powers, the scheme of separation of powers and the federalism scheme were to be the first line in the defense of individual liberty. And that remains true today. But it nevertheless is the case that this dispersal of power may not be the optimal defense against a pandemic. That's a complicating factor in American government. And then I think there's a step two, and I want to just say very briefly what the step two is. There's the step one, and then there's the step two. The step two is whatever the scope of the power, and whoever is the appropriate actor, the state actor exercising that power, is the exercise of that power limited in some way by affirmative individual rights, protections enumerated in the Constitution or implied in the Constitution, either the federal Constitution or the state constitutions. These are rights like the right to free speech, the right to the freedom of assembly, to the freedom of association, to religious exercise, rights of property, rights of bodily integrity, rights of equal protection, all of the kinds of Con Law 2 issues that you recall from your constitutional law classes. So let's go back to the sort of Con Law 101 sort of analysis. And I'm going to stop sharing for the moment. Hopefully you're now seeing me mostly on the screen. The basic principle of American constitutional government is that the federal government has only limited and enumerated powers. These are the powers that either are explicit in the Constitution or they are implicit in the constitutional design. All of the remaining powers are reserved to the states through both the implication of the structure of the Constitution and through confirmation explicitly in the 10th Amendment. The federal government does not have, and this is a step one question, the federal government does not have a general police power. It has no blanket power, the police power has no blanket power to protect the public health or safety. That is a power that belongs in general terms to the states. So where would the federal government get the power to deal at all with COVID-19? Well, there is no public health clause in our Constitution. There is no pandemic clause in our Constitution. There is no emergency powers clause in our Constitution, unlike some other constitutions around the world which do have emergency powers provisions. Ours just does not have that kind of a a provision. Instead, the power of the federal government to deal with the question of defending public health or preserving public health really rests with, and I'm trying again to share this screen, really rests in three areas of the Constitution, three specific passages in the Constitution. First of all, we have the Commerce Clause, which I put up on the board, but which you should need to read because all of you have your pocket constitutions with you, I'm sure. That gives Congress the authority to regulate international and interstate commerce. The court has understood that power as allowing Congress the general power to regulate all economic activities that substantially affect the national economy. So if you apply that principle, that Commerce Clause principle to public health, the federal government has the power to make laws and to regulate in areas affecting international and interstate transmission of disease. For example, at a minimum, the federal government has the power to stop the movement of, say, diseased persons or animals or crops across state and international borders. It could do that at a minimum and probably is going to be able to do much more than that. A second power that is important, and that is the power. Actually, I had the spending clause power up earlier. I should have started with the commerce power. So the slide you have up now is the spending clause power. That's the power of Congress to tax and spend for the general welfare. So applied to public health, the federal government may spend to assist states in their efforts to control their responses to public health emergencies and provide for various forms of relief to individuals, to industries, and to businesses in order to respond to a pandemic and to deal with the effects of a pandemic. The various coronavirus relief bills fall certainly within this spending and taxing power. The stimulus checks that were sent out earlier this spring draw from this power. The payroll protection programs, all of that is part of this power that Congress has. So then we have the power to regulate commerce. And finally, there it is, we have the necessary and proper clause. This gives Congress the power to make all laws necessary and proper to carry into execution all of the enumerated powers. So those are the three basic powers that, for the most part, allow the federal government to deal either directly or indirectly with a public health emergency. There are other powers that may be implicated, but these are the most likely of the three. So I'm going to stop this. Slideshow for the moment and just get back to where I think these federal powers, at least, are actually going to be exercised. Congress can only do so much in the way of legislation. So effectively, what it has done is to delegate a lot of whatever public health powers it has to the president, to the executive branch. The president, therefore, and various agencies in the executive branch, like the Department of Health and Human Services, the Centers for Disease Control, the CDC, the FDA, and so forth, those bodies have been authorized to deal with the pandemic in a variety of ways, and they do so drawing on numerous statutes that Congress has passed authorizing the exercise of those powers. So, for example, the president can issue executive orders that do things like list communicable diseases for which a quarantine could be ordered. The Secretary of Health and Human Services can make regulations to prevent the spread of disease within federal jurisdiction, like imposing quarantines and isolation orders and doing a whole list of things. Federal law also authorizes the Secretary of Health and Human Services to care for and treat persons who are quarantined, or to assist states in enforcing their own kinds of quarantine orders. So the validity of the executive's power within our constitutional scheme, and really in all cases, but including in these public health cases, rests on the answer to a couple of subsidiary questions. One of them would be this: is the exercise of the executive's power truly within the constitutional authority of the federal government as a whole? So Congress could not give to the president the power to exercise some authority that it itself would not have. That's the case. So that's a limitation on the president's power. The president is limited by the overall powers of the federal government to deal with the pandemic. And then the second question would be, assuming Congress can delegate some power, can give the president some authority, is the president acting within the scope either of the statute that the Congress has passed, and that's a statutory interpretation question, or within his own independent constitutional power in Article 2, if he has such a power to deal with those things. Now, I want to highlight just a couple of ways in which the existence of this coronavirus pandemic have affected national policy in, I think, perhaps unexpected realms. One of them is immigration, something you wouldn't think of immediately as a matter of pandemic control, but it does actually involve some pandemic-related issues. So Congress has broad control over immigration and naturalization, but it has in fact delegated much of that authority in very broad terms to the president. So in March, the Trump administration implemented sweeping emergency border controls that waive standard immigration proceedings for protected groups, including for minors. Those procedures under the Trump administration's policies allow for rapid deportation of individuals who cross the border illegally. And that has been justified, according to the administration, by the desire to stop the spread of the coronavirus across international borders. And in fact, because that policy needs to be justified, it needs to be rationalized in some way, the president has asked the CDC, the Centers for Disease Control, to come up with a public health justification for those orders. Now, those are very common step one questions. What is the scope of the president's authority? Is the president the right actor? Can the president act under the statute? And what are the limits of the overall national power of Congress to deal with these issues? But immigration rights groups have sued the federal government, arguing that the expulsions violate the legal protections that minors that are designed, at least, to prevent minors from being subjected to child trafficking and abuse. That's both a step one and a step two issue, the scope of the president's powers, and it goes to questions of rights, limitations on those powers. But it turns out that illegal immigration is at a 13-month high, or at least it was in September. So we now have more than 1,900 minors that are in federal custody and control. That's up from 800 just a few months ago, and the federal government has run out of space to house these minors while they're in the process of being deported or being evaluated for deportation. So now the Trump administration is trying to justify the detention of minors in hotels because their camps aren't available, that there are now hotels they're being put in. And these hotels involve just putting these children up in hotel rooms where they're largely unsupervised and where members of the public can come and go. that seems contrary to any kind of good coronavirus response where you don't want members of the public coming and going and interacting in these enclosed spaces and then spreading the disease around the country. So the administration has been pressuring the CDC officials once again to sign a formal declaration that those detentions would in fact be an effective public health measure. Now, some CDC officials are obviously resisting what they regard as inappropriate political pressure on public health matters. So that's one kind of unexpected issue. Another involves the CDC's recently announced policy regarding evictions. This, I think, is little noted. You may remember it from last August, but in August, the CDC had announced a policy barring evictions until the end of the year. And these evictions involve any residential tenant who makes a sworn declaration that swears to, I think, about 4, 5, 6 different things, including I've tried to pay my rent and I can't pay it. I've paid as much as I can. I've sought government assistance to be able to pay the rent. I don't make more than $100,000 a year, or $198,000 if you're a couple. And it's likely that if I'm evicted, I would be rendered homeless. The claimed author, you may wonder, where does the CDC get the authority to halt all residential evictions under these specific criteria for a specific period of time? The claimed authorization is a small part of the Code of Federal Regulations, which in fact gives the director of the CDC the power to do the following, and I quote, "Take such measures to prevent spread of a communicable disease as he or she deems reasonably necessary." Measures to prevent the spread of disease. You can take those measures. And then it lists some of the measures that are commonly used by public health authorities: inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals and articles believed to be the sources of infection, and so forth. Now, those are common public health measures. Much less common was this interpretation by the CDC that it could actually stop evictions. Now, there's a reason why you might want to stop evictions, because obviously when people are in these congregate settings of homeless shelters or just homeless because of the pandemic or because of the countermeasures and the economic effects of the pandemic, there's the opportunity for spread of disease. And the CDC says that whenever we think that state regulations or local regulations are going to be insufficient to limit the spread of disease across state borders, we can do that. We can do that. Well, where does that regulation come from? The regulation comes from a statute authorizing the Secretary of the Department of Health and Human Services to issue regulations in order to try to prevent the spread of communicable diseases. That's a very broad reading of both the federal regulation and of the statute, but it's a reading that in these times, at least, the administration felt intense pressure to try to issue. Now, this is a very standard kind of step one issue. It's a question of the scope of the president's authority, and then it's a question also of whether, given the scope of that authority, does the federal government have the power to deal with evictions in the states? And even beyond that, if the government has that power, can this authority be conferred on the executive branch? And that raises issues of federalism. It raises issues of statutory authorization, raises issues of separation of powers. Those are all step one issues. Then it raises also issues of property rights and possible takings clause concerns under the Fifth Amendment. And wouldn't you know, landlords and the housing industry have sued to try to prevent the implementation of that regulation. Now, I don't want to leave the the campaign completely untouched. I won't leave entirely untouched the plans announced by Joseph Biden, who may be elected, we'll see, on Tuesday. His campaign has announced plans for what you might sort of call a COVID New Deal. A COVID New Deal. We heard of the Green New Deal. We may have now a COVID New Deal. And Joseph Biden was actually heard to say, I'm kind of in the position that FDR was in. Now, hopefully you're seeing a picture of FDR on your screen now, the jaunty cigarette holder that he used to use at this sort of angle. Very classic FDR. And for Biden, you could call him Joseph Delano Biden, I suppose, because his proposal is what we need is more concerted and aggressive government action. We don't need the basic leave it to the states approach, the hands-off approach that the Trump administration has been more inclined to pursue. So there are several elements of this COVID New Deal. One of them is simply to increase testing from 30 million tests a month to 100 million tests a month, more money for PPE, more money for schools to prevent infections, more money for hospitals. These are all spending issues, and they're spending from existing accounts or maybe authorizations for new spending by Congress. At any rate, they're kind of step one issues of the kind that I have mentioned. Biden has also discussed the appointment of a national supply chain commander who would coordinate the logistics of manufacturing and distribution of protective gear and test kits, the buildup of the national strategic stockpile of medical equipment, presumably also the distribution ultimately of some kind of vaccine, hopefully in the spring. And I assume that this plan, it's not clear exactly what it means, but I assume it would mean ramping up and invoking more aggressively the provisions of the Defense Production Act, which is another one of these provisions under which Congress has given the president a great deal of authority to try to marshal the resources of the country to deal with an emergency. And that President Trump has used to some limited extent, used it, I think, last April, but not as much as I think Joe Biden would do. Biden is also suggesting he would mobilize at least 100,000 Americans for a public health job corps of contact tracers to kind of keep track of the pandemic and curb these outbreaks. It's not clear exactly what this proposal would involve exactly, but it may require new legislation. I'm not sure that the president can go out and just hire 100,000 people for a public health job corps. He's also proposed a pandemic testing board, which would try to swell the supply of coronavirus tests in the country. That, I think, is a play on President Roosevelt's War Production Board. That may also well require new legislation, although maybe it could be done under existing legislation. And he's mentioned the possibility of a national mask mandate of some kind. And what Biden has said about this is that the question is whether I would have the legal authority as president to sign an executive order. And I do think that is a question. He did say after that, he said, we think we do. We think we do have that authority to sign an executive order with some kind of national mask mandate, but I can't guarantee that yet. Now, where would that kind of authority come from? Well, I think this is a classic step one issue. The president doesn't have an independent constitutional power to issue a national mask mandate order. I don't think that would be the grounds for the president's declaration. It could be that the president could derive that authority from an existing statute, namely Section 361 of what is known as the Public Health Service Act may in fact permit the CDC to issue a national mask mandate of some kind in some circumstances to prevent the foreign or interstate transmission of COVID-19. That is the same statute that the CDC used in August under the Trump administration to justify the ban or partial ban on evictions nationwide. That's the kind of sweeping authority we're talking about. Would that be, on a step one analysis, the kind of thing the president could do? I think it depends on what the extent of the order would be. You could order it, I think, in federal buildings and on public land, in channels of interstate commerce, airplanes, ships, railroads, etc. Maybe you could order it as a condition for any person who's engaging in some kind of economic activity, like going to work or shopping in a store, on the grounds that they are engaged in an economic activity that will substantially affect interstate commerce. And the court has been quite generous about this federal authority. So you've got a statutory issue and you've got a constitutional issue, and then you have the other issue that I'll try to get to in a moment about possible separation of powers issues. You probably could not simply order people sitting alone in their homes who are just, staring into a cold, godless galaxy to wear a face mask in those circumstances, because they're not engaged in any kind of activity whatsoever. And the court has suggested you can't make people engage in activity just so that you can regulate them. It said that in the Obamacare case, as many of you recall. I think the problem with the president's order, any kind of order, at least the more extensive the order, the more of a problem it would be, is with enforcement. How are you going to go about enforcing a national mask mandate? Again, depending on how extensive it is, we don't have CDC police to issue tickets and fines. You can't commandeer the state and local police. That's contrary to the anti-commandeering federalism principle. Maybe you could enlist state law enforcement through some kind of conditional spending, where Congress sets up a program and tells the states you can get access to this money as long as you enforce a mask mandate. I think more than anything else, a mask mandate would be an effort to sort of set an example and set a tone for the new administration. So most of the really controversial issues have come in the states. That's where most of this action is. Most of the action in the area of restrictions on, in the form of stay-at-home orders, in the form of mask mandates, in the form of business restrictions and restrictions on all kinds of activities, have actually come from the states. That's where most of the action is. And as I say, most of the controversy. Just take Texas for an example. Texas has a couple of statutes that deal with infectious diseases and allocate powers. The Texas Disaster Act is one of those statutes that allows the state to deal with pandemics, epidemics. And then you have another statute called the Communicable Disease Prevention and Control Act, part of the Health and Safety Code, that also allocates powers between state agencies and local health authorities. Again, a statute that comes into play. I think the most important of these acts, at least the one I want to focus on the most in Texas, is a statute that for 50 years has been known as the Disaster Act, that grants the governor unilateral power to declare a state of disaster. Now, mostly these declarations involve things like hurricanes and tornadoes and fires and that sort of thing, but they can include epidemics. And Governor Abbott did, in fact, declare a state of disaster for the pandemic beginning on March the 13th. And he's declared a continuing state of disaster every month since March the 13th. And I'm sure that he will continue to do so. And it is true that the legislature can overrule what the governor says. The legislature can say there is no state of disaster, but the legislature isn't scheduled to meet again until January of 2021. I mean, it is the fact that Texas legislature meets only biennially, once every 2 years, which some people regard as a very good thing for the liberties of the people of Texas. But in this case, it means that the governor is being given a whole lot of extraordinary authority. The Disaster Act says he is responsible for meeting all of the dangers to the state and its people presented by the disasters. He has discretion to use all available state and local resources, even to commandeer the use of private property if the governor finds it to be necessary. He has the ability to control the movements of people in disaster areas, egress and ingress. He may restrict the sale and transportation of items like alcoholic beverages. This is part of the bar orders that the governor has announced, and it's part of the business closures that he has announced, or the capacity limitations that he has announced. In a disaster, the governor becomes, according to the Disaster Act, quote, the commander-in-chief of state agencies, boards, and commissions. And this is just as close to a state of war as Texas can get, except the governor has the power to unilaterally declare it and to do so indefinitely, or at least until the legislature decides otherwise when it gets around to meeting. So under that order, under that power, the governor has done a whole lot of things, not as much as some people would like him to do, and maybe not as quickly as they would like him to do it, but he has done quite a bit. For example, early on in the pandemic, the governor halted all non-essential surgical procedures, and that included abortion procedures. Now so there's immediately a step one issue here. Was the governor's order within the scope of the authority that was given to him under the Disaster Act? Is that the kind of thing the governor could do? The governor said, yes, of course it is. Non-essential medical procedures affect the use of medical equipment. They mean that people are going into congregate healthcare settings more often, and we need to limit the amount of that that's going on to prevent the spread of the coronavirus. We want to prevent the infections. We want to preserve the PPE, the hospital capacity, and so forth. And that issue was actually not seriously contested early on in the days, in the early days of the pandemic. And this, I mean, late March and early April. But there was a challenge to this order from abortion providers who noted that abortion is a fundamental right under the US Constitution. Roe versus Wade says that. And Planned Parenthood versus Casey said that a government could not place an undue burden or a substantial obstacle in the path of a woman seeking an abortion. This was a ban on abortions for at least the period of the order, which was a 2-week period. You can't place that kind of substantial obstacle. And so this is a classic step 2 question. If the governor has the authority to limit in general non-essential procedures, does the governor have the authority to do so in the context of the exercise of a fundamental right? The answer to that question from the Fifth Circuit, and this is a decision that came right around the beginning of end of March, beginning of April, was on the step 2 issue about fundamental rights. The answer was the governor's order was perfectly constitutional, and the court, mainly for its analysis, was guided by a 115-year-old precedent called Jacobson versus Massachusetts, which is an opinion that upheld this 115-year-old precedent opinion that upheld a mandatory sterilization law in Massachusetts that was designed to prevent a smallpox outbreak. And under that sort of rubric, if the state is pursuing at least in a public health emergency, a sort of public health objective, there's very limited judicial review. Essentially, the law would only be unconstitutional if it were patently unconstitutional, and if it were arbitrary, oppressive, unreasonable, if it was, in the words of the court, a plain and palpable invasion of fundamental rights, and there was no real substantial relationship between the measure and public health. And the most important thing is this: if there's a choice between two reasonable options, employing the means the government has chosen and upholding the rights of the individual, the court was supposed to defer to the judgment of the government. So if there's any medical uncertainty whatsoever about the necessity for the order, wide discretion is given to the government, and that uncertainty is resolved in favor of the restriction. And the court said that applies to all constitutional rights, including religious exercise. And that case was then cited in all of the abortion precedents that the court later on decided. That's a step two conclusion. And I think this sort of analysis about these restrictions on constitutional rights were quite common early on in the days of the pandemic, in the first month or maybe 2 months of the pandemic. The step one issues that I mentioned were not seriously contested. The step two issues were resolved under this deference approach of Jacobson. The problem, I think, with this analysis is this: Jacobson was decided in a very different era. It was decided during the early 20th century police power days, when the conception of the police power at the state level was very, very broad. It was decided in an era when fundamental rights were not really fully recognized in the modern sense. And it was decided in an era when the levels of scrutiny, of judicial scrutiny that we have come to know, the tiers of scrutiny, of strict scrutiny and rational basis scrutiny and intermediate scrutiny, those were just unknown. We didn't have those tiers of scrutiny yet. So I'm not sure that those kinds of things would actually still apply. Could also mention the governor's shutdown orders, where the bars were shut down in late June. There were capacity limitations on other businesses. The justification for these orders, again, was public health, that bars are especially bad congregate settings, and that they're among the worst kinds of things that settings in which people gather and spread disease. The bars sued, as did some other businesses. And they have sued in state courts and in federal courts, and they've used a hodgepodge of arguments. One of them is a step one argument. They've tried to use a separation of powers argument and said that the governor has acted beyond the scope of his statutory authority. More on that, I hope, in a little bit. And then a step two argument, they've argued that, look, businesses, including bars, have a right to pursue a living, to earn a living, to operate their lawful businesses without unreasonable restrictions, and these restrictions were just unreasonable. Furthermore, they argued beyond that sort of fundamental right to pursue an occupation argument. They argued that the governor's order sets up these essentially arbitrary classifications of distinctions between a single standalone bar on the one hand and a bar that's attached to a hotel on the other. So the governor prevents a standalone bar under this earlier orders, prevents a standalone bar from opening, but doesn't prevent the same kind of bar from opening if it's attached to a hotel. It's the same kind of setting. What sense does it make for the one set of bars to be shut down, but not the others? All of them involve people congregating in ways that can be dangerous, where their judgment is impaired in various ways, and they just can't be trusted to act appropriately. So far, those efforts have not been successful in Texas, but watch this space, as they say. And then the governor issued a face mask covering order, which again was not seriously challenged under the step one portion of the argument, at least not so far. There have been some challenges, but the mask order has been upheld, the limited mask order that the governor has issued. that has been so far at least upheld. And there is evidence that masks are actually probably the cheapest and most effective structural public health intervention that the government can impose at this time. I do want to mention a couple of the other states and the restrictions that have appeared in these states. So California, for example, and this has been common throughout the states, California, the governor imposed a capacity limit on businesses and churches of 25% of their ordinary capacity, or no more than 100 people, whichever is greater, or whichever is less. There were some churches who claimed that this violated their free exercise rights under the First Amendment. And undoubtedly, these are restrictions on places of worship, which does implicate vital First Amendment freedoms of free exercise. And so these are step two issues. So beyond the step one issue, you have a step two issue. The churches make this claim, but the question really is, has the government singled out religion in a way for a sort of special burden, or has it treated religion in the same way as it treats comparable secular places and activities? California argues that we treat churches just like comparable secular settings. So we restrict lecture events, concerts, movie showings, spectator sports, theatrical performances, any place where there are large groups of people who congregate in close proximity for any period of time. And it's true that the order was more lenient toward other kinds of establishments that present less dangers to grocery stores or banks or laundromats, where people are not quite as close together. They're not singing in proximity to each other, speaking to each other loudly for long extended periods of time. So they're just less dangerous. So we can draw the line in that way. We haven't singled out religion. There's a disagreement about what's a comparable secular activity. And there was a disagreement when this issue reached the Supreme Court a couple of times this summer, but the majority ultimately decided, at least in the emergency circumstances that the issue presented itself, that California could go ahead and impose these capacity requirements. I'm not sure that in the long run, these cases are going to come out exactly the same way. We have, for one thing, a change in the court now, but we also have a little more experience with the pandemic, and we'll see how those cases come out a little bit later on. Another case out of Pennsylvania, an interesting case out of Pennsylvania, involved, again, congregate limits on gatherings, stay-at-home orders, and the closure of non-essential businesses. This Pennsylvania case was decided by a Pennsylvania district court in a sort of step two analysis. It said, first of all, the congregation limits violate the rights of assembly under the First Amendment. The stay-at-home orders violate the rights under the 14th Amendment, unenumerated rights to things like rights of travel, a right not to be subject to involuntary confinement and so forth without at least due process of law. And then, most interestingly of all, the federal district court in Pennsylvania decided on the question of the due process clause under the 14th Amendment that there was an unenumerated right to work and pursue a calling, and that is a species of liberty of contract that was protected last during the era of economic due process. And that was an era characterized by a case called Lochner versus New York, which the district court actually cited in a favorable way. But of course, the Supreme Court has not cited Lochner in a favorable way since 1935, when this man was president of the United States. So we'll see what happens with that decision. The district court concluded, quote, "The Constitution cannot accept the concept of a new normal where the basic liberties of the American people are subordinated to open-ended mitigation measures. Rather, the Constitution sets certain lines that may not be crossed even in an emergency." There have been similar cases that have come out recently in district courts. The DC District Court, for example, held it was unconstitutional for DC to limit the size of worship services and struck down other requirements. There was a Colorado case that did pretty much the same thing, especially with respect to religious services. All of these are a species of step two reasoning of the kind that I mentioned before. But I want to mention a much more interesting question, and that is, we're starting to see not just more skepticism on the step two issue, but skepticism on the step one issue. So consider a case that came out of Michigan. Businesses challenged the governor's orders in Michigan, limiting, again, capacity of businesses, closing some non-essential businesses down and issuing various other kinds of orders, limiting public gatherings and so forth. Just like in Texas, Michigan has an Emergency Powers Act that vests broad powers in the governor, allows the exercise of those powers indefinitely, unless there's some more action by the legislature. And those orders by the governor were challenged in Michigan in federal court, but the federal court in Michigan certified certain state law questions to the Michigan Supreme Court, which accepted those certified questions and proceeded to pronounce that the governor, in fact, had overstepped her boundaries of separation of powers, basically saying that although the governor had correctly interpreted the scope of her powers under Michigan's emergency powers statutes, the legislature had delegated too much authority to the governor by giving the governor essentially unbridled discretion to do whatever the governor thinks is necessary to stop the progress of the pandemic. And that, they said, violates the old non-delegation doctrine. And the court relied on cases, the federal cases from the non-delegation area, where the court has upheld every single delegation that it has seen since 1935, when this man was president of the United States. And so I think we're beginning to see action even on the step one issues, pressure increasingly. So let me just conclude with this. In the past week, we just had 500,000 confirmed coronavirus cases in this country. We have a hospitalization rate that has risen 46% in something like the last month. This is likely the beginning of another upward slope in the course of this pandemic. States and cities, and for that matter, countries around the world, are starting to impose new restrictions or reimpose old restrictions. El Paso in Texas, for example, just imposed a 2-week curfew on everybody from going outside of their homes. And yet, at the same time, we're probably only at about 10% of the population that's been infected, which means that 90% of the population is still vulnerable. We are looking at a long, hard road ahead with a projection of maybe 400,000 Americans dead by February 1st, by the time the new presidential term begins, whoever that president is. What's developing here is, I think, best described as a kind of constitutional pincers. Forceful and coordinated command and control strategies by the government to address the pandemic is being caught between the rock of step one, separation of powers, maybe federalism, statutory authorization, and the hard place of step two, religious liberties, economic liberties, assembly, First Amendment rights, and so forth. maybe that's the inescapable constitutional result. Maybe that's just the constitutional system we are in. But I think state and federal courts are going to find themselves increasingly on the horns of their own kind of dilemma, namely the need to protect liberty and society's need to protect public health. So with that, I'll turn it over to questions if you have any questions.
All right. Thank you, Professor Carpenter. And let me encourage the audience to submit your questions using the Q&A feature on your screen. I have a first question for you. You indicated, I think, that some state and federal courts have started to express somewhat more skepticism about the constitutionality of pandemic countermeasures. Do you see any signs in Texas with respect to Texas courts heading in that direction?
It's difficult. I think you could see the beginning of both step one and step two increased skepticism. Some of you, I'll start with just with step two. Some of you may remember the controversy earlier this year, I think it was back in April, when Shelley Luther refused to shut down her salon. I think it was called Salon a la Mode, in contravention of the county's orders and the governor's orders to shut down the clinic. And then that case ultimately went up to the Texas Supreme Court on a contempt of court citation, where she was actually placed in jail for contempt of court. And the Texas Supreme Court basically said, liberate Shelley Luther, who I think is now running for public office. But the court didn't issue a substantive opinion on that question. But there was a very interesting concurrence, and I would urge people to take a look at this. This is a concurrence by Justice Blacklock, joined by 3 of the justices on the court. So that's 4 justices on the court, saying that government power in this country is not subject to suspension. I mean, government power in this country is limited by constitutional law and constitutional rights, and those rights cannot be simply suspended for an indefinite period of time. And some level of scrutiny is going to need to be applied that's commensurate with the robustness of the protection of those rights, including freedom of worship and assembly, and maybe right to pursue a business calling or whatever it happens to be. Maybe that's the start of a step two kind of questioning. We could see more of that in Texas state courts in the future. There's been a little bit less on the step one question, but the governor has been relying on this Disaster Act again, which it goes on and on until the legislature brings it to a halt, maybe next session, maybe not. But I think there was an interesting opinion last night. I promised not to talk about voting rights, but there was an interesting opinion last night from the Texas Supreme Court that basically upheld the governor's decision to limit the drop-off sites for mail-in ballots to 1 per county. And the court said in an interesting footnote that the plaintiffs have not challenged the Disaster Act under the Texas Constitution. So the governor had acted basically to suspend the voting provisions of the Texas Election Code, and he'd done so under his Disaster Act authority to try to prevent coronavirus infections. But the court said, well, nobody's challenged the Disaster Act's constitutionality, so we're not going to deal with that. I don't know what that means. I don't know whether they're inviting a challenge along those lines. I kind of think that if you pay attention to what happened in the Michigan Supreme Court, we could start to see step one challenges in addition to step two challenges as the pandemic goes on.
Okay, thanks. We had a question come in. Do you think the Supreme Court will back away from a recent ruling that the governor of California had authority to limit church attendance to 10 or fewer attendees now that Justice Ginsburg has been replaced by Justice Barrett?
Well, so we don't know for sure what Justice Barrett is going to say about the capacity limitations. And mostly, I think the question confronting the court at least under current constitutional doctrine, is, has religion been treated in a way that is comparable to, similar to comparable secular activities? And so there's all kinds of judgments about what constitutes a comparable secular activity. What is comparable to people gathering together in close quarters for long periods of time and singing, as people do in worship services and so forth, and maybe hugging in these congregate settings indoors, and what's not comparable to that. So that will be a crucial determining factor, and I don't think we know where Justice Barrett stands on that issue. The other interesting question is that it's quite possible that in a case that Justice Barrett will sit on I think the day after the election, involving same-sex adoptions and foster care in Philadelphia, the court may actually ratchet up the degree of scrutiny it gives to religious exercise claims, free exercise claims, and get rid of that old rule that says anytime you're just burdening religion equally, only rational basis review applies. And it may actually say, well, actually, if you're burdening religion, you have to meet something more like strict scrutiny. You have to have a compelling justification.
All right, well, I wish we could keep asking you questions because these are so interesting, but we're already about 5 or 6 minutes over, so we'll stop there. But with that, let me thank you, Professor Carpenter, for your presentation. Thank you to the audience for joining us. Let me make 2 additional points. First, as I mentioned, if you're an attorney and you'd like CLE credit and you did not provide your bar card during your registration, you can send your bar card number to our email address, tiecenter@smu.edu. Second, as Professor Carpenter mentioned earlier, our next installment in the series, it's going to be on Thursday, November 12th at 12:15. We'll have Professor Pam Metzger. She'll be discussing criminal law in a time of COVID. To register, watch for a link on Twitter @SMU Tie Center, and we'll also send out emails so you can look for that as well. We look forward to you joining us. Thank you and have a great rest of your day.